We're gonna go in 3, 2, 1, let's go. Welcome to G Money Real Talk on everything mortgages and real estate. And today I'm here with Crista Hermance, the estate planning mom. Welcome, Crista.
Thank you for having me.
Yeah, so let's dive right into it. You know, it's I always love to kind of talk about how we met one another, but then it's like I feel like as soon as I met you, our circles overlap times 10. And then I try to claim, I feel that, as far as, Sarah, myself, our business, our nonprofit, we're into everything is what I feel like. And I'm like, how do we do it? And then I look at you and I think you're like 110% of us. I'm like, you're raising the bar even more than us, which is amazing. So
I
kudos to
appreciate
you.
that. And just to hear anybody say that is it feels really good. So thank you.
Yeah, we were downtown one of the recent fairs and we were eating at Perano's, and right there was the Hermance Law booth, and I'm like, I'm over here just wandering around eating and they have a booth today. I'm lagging, like what's going on? So, oh my goodness.
Yeah.
Well, I love it. I mean, it's spreading the message, and I think that's ultimately what you try to do. I mean, you do a ton of workshops, you do a ton of outreach, lunch and learns. We've got our top 100 group going, we'll talk about. So let's just start from the beginning. What is it that you do?
So I am an estate planning attorney.
Okay.
So estate planning is not really in the world of real estate, which a lot of people don't understand that. They think I might sell a house as, as an estate planning attorney. But we do wills, trust, probate, trust administration. So basically planning for somebody to get sick or planning for somebody's passing. And then on the other side of it is if somebody passes away, we help the family figure out what needs to be done to be able to distribute assets and figure out what they have and what those next steps are.
Yeah. You say you're not in real estate, and I understand you don't sell homes.
Correct.
But you're very much part of real estate.
Yes. It's the selling part is what people would think when not knowing an estate planning attorney was.
Gotcha. Let's go back, and this also kind of intrigues me, is to say you're an attorney, there's a lot of different worlds of that. I mean, how did you get into specifically the estate planning portion of that?
So when I started my career, I actually volunteered at the district attorney's office, and I was a volunteer victim advocate for the domestic violence victims unit. And I was in court and I was helping victims. And so that really started kind of my law journey. I got a job working for a firm in Westlake Village. I started as a legal assistant, worked my way up, and I was with that group while I was going through law school, passed the bar, I became an attorney for them, and that's where I kind of got my foot in the door with estate planning. From there, I just really enjoyed the planning side and working with families because there wasn't the type of feelings that you have when there's like a family law matter, when there's a divorce, when there's child custody. I did not like that side. And so I was really looking at working with families where they weren't in this situation of, being in that impending divorce or something. So it was just a different type of law to practice and the feelings you get from it. And that's what I enjoyed. And so from there, it kind of sprouted. And the more work we did, we took on different types of cases and then really got into the probate and trust administration. We do trust litigation at this point as well because we've been doing it for about almost 10 years now.
Yeah. Wow. Yeah, it's, I like, just kind of what you said, because it's more about the planning and, a lot of people, I think it's out of sight, out of mind. And especially why I want to have you here today is how it relates to mortgages so much is, one, if you're doing a mortgage and you have a trust, we do need to get a little bit involved, and that's kind of part of that, but it's also as you're acquiring an asset, and I help so many young couples, it's an asset and it's long-term, and it's like, okay, now you have it, what's the end game? And it's like, if you're not prepared, and I'm sure we'll go down the road here in a little bit about probate and worst case scenario, you just don't want to lose that. And so the more prepared you are, and it just really helps, in terms of your family, your heirs, etc. So it's really cool. So with kind of what you do in the outreach, and I know you do a lot of I don't want to say promotions, but you're promoting the business and the industry. Is it a lot of like just basic education of, what's a will, what's a trust? I mean, kind of what's a typical, lunch and learn for you?
So it really depends on the audience that we're speaking to. So
Sure.
we do lunch and learns for, like the one we just recently had was for professionals. And a lot of them were real estate professionals, because those are really people that need to get information so that they can be better equipped to help their clients as they're buying homes or doing mortgages or some kind of title insurance. And so for those ones, my goal in those is to share stories with them that will help them kind of trigger things when they're dealing with clients to say, you know what, I think you might need some help with this, so that they can kind of see some scenarios of how estate planning could prevent something from happening if they see it.
Yeah.
And so that's really when we're looking at professionals, right? Doing those kind of workshops for professionals. On the other side, we do it for people that are, going to be clients or people that are interested in estate planning. For those ones, it's really like estate planning 101. It's sharing with them what the basic estate planning documents look like. What is a will, a trust, power of attorney, advanced healthcare directive, and why is it important, right? What is the reason for needing an estate plan, especially in California? It's so important to have an estate plan in place, specifically a trust, and we'll talk more about that.
Yeah.
And for there, that's where we're really educating them on why they need an estate plan. And once they leave that workshop, they are now informed and can tell their family and friends. And that's honestly what happens, is they will share the things that they learned from the workshop to say, hey, did you know that this was actually how it works? Because that's really what it comes down to, is people just don't understand estate planning.
Right. Yeah, no, it's foreign, it's unknown. When it's unknown, it can be overwhelming. And I obviously get that quite a bit with mortgages. You're my first step. I don't even know where to start. It's intimidating. And obviously, if you go down the Google, path, it's endless and it is way overwhelming. I get overwhelmed just trying to find certain things at times. I love your approach, and I can't say that enough. It mimics what we do, is very educational. Yes, we're here in business for profit, but our hearts are sincere and genuine, and I see that in you. And it's the amount of outreach that you do to get the message across. Again, I'm giving you props. I can't say it enough. You're doing a great job, so keep it up. Let's dive into just the basics 101. A will, what is a will? And then we'll talk about a trust, and we'll just kind of go from there. So what's a will?
So a will is a legal document where you can identify an agent that's going to be responsible for administering your estate after you pass away. A will only actually comes into play when somebody passes. At that point, the will is filed with the probate court, thereby starting a probate proceeding. In your will, you can say, here's how I want my assets distributed, and here's who I would want to be guardians for my minor children. The biggest misconception with having a will is that if you have a will, it will avoid probate court. And that is just not true, right? If you have assets, the will is basically going to guarantee probate court, because it's telling the court how you want your stuff distributed.
Yeah.
So
it's just more or less your basic wishes that you're putting down in a document. Now, I have a few friends that are attorneys, and this is going back like way, 20 years. I don't know if it's correct, but they said when I did it myself, just like in my early 20s, don't type it out. They want it handwritten because of your writing. Is that correct?
So there's different types of wills, and the will that you're referring to is called a holographic will.
Okay.
And a holographic will means it's something that somebody would have written in their handwriting and dated it and signed it.
Yep.
And that is basically what a valid holographic will is, and that is admissible in court to be used as a will. And the reason that they probably said that is if you were doing it on your own, if you had just done a typed one, there's nothing that can prove your writing.
Yeah.
Right? And so to make sure that it's valid, having it in your writing is going to help that.
Sure. Okay. And then supporting that is the trust component. And I don't want to say that's more official, although it's probably crude terminology here, but that's where it's the executable plan of how your assets take place and what occurs, and beneficiaries, successors, right? Wrong, maybe?
Yeah, no, that's a good way to put it. So I like to think of a trust as an agreement, and it's an agreement between the grantor, which is the creator of the trust, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust, and the trustee follows the instructions in your trust for the benefit of your beneficiaries. And while you have a trust, also known as a revocable trust, a living trust, a revocable living trust, or just a trust, they all mean the same thing. You are all three of those roles. You are the grantor, meaning you are creating it. You are the trustee, meaning you are in charge of your assets in your trust, and you are the beneficiary. So while you are alive, when you have this trust, you are the one is doing everything for this trust. It's all your stuff. You can use it how you want. You want to buy a house, you buy a house, you put it into your trust. You want to sell the house, you sell the house as the trustee of your trust.
I don't know if this is a good analogy, but I've always kind of considered it kind of like a corporation, where if you're self-employed, you have yourself, but then the whole purpose of the corporation is to provide a little bit of a distance and some protection. And so it's creating like this false person, right? And through that, it just kind of has a legal arm or a distance where if you have any lawsuits or something, that's the whole reason of the corporation. But again, I think the whole distance person, to me, if obviously when the trustor passes, then again, it carries on. It just doesn't end right there at death. Is that a decent analogy?
It is to a point. So definitely when the trustor passes on, at that point the trust generally would become irrevocable.
Correct.
Meaning nobody can make changes. It gets its own tax ID number, and it is then in this kind of protected mode that is going to provide the protections for the beneficiaries. And you do have that separation, like you were saying, like you think of it like a corporation, but it's still your stuff, right? You still have access to it. You don't get a different tax ID number. It's all your social security number. Like everything is associated with you, so that you have the ability to use it or to make changes or to sell it or to add more stuff to it. So there is a different separation, but it doesn't provide that legal protection that a corporation would.
Sure.
Right? And because that's not the way that the revocable trust is set up. The trust is revocable because you can make changes, you can add stuff, and you have access to it.
Yeah. And then I see trusts all the time. Obviously, many people put their assets, rightfully so, like their home, into it. And, you know, I'm always, I don't know, you see the names of the trusts, and most of them are vanilla, like the Gregory Joseph Abrams Trust, dated August 8th, 2024. Is that pretty standard?
Yeah, it's a very standard way to do it, and it's actually how we do it. We sometimes have clients that want very extravagant names, and oftentimes we will try to persuade them against it. And the reason for this is the assessor's office could potentially try to reassess the property if they cannot establish that the trust is the beneficiaries who lived in the house before. And so if their name isn't on the trust, they're going to need to see the trust to actually see whose house this is.
Right.
So in an effort for us to try and prevent reassessment, we will just say, you know, can we just make it the name of you as the owners of the house, to put it into your name just as it's listed the same. Yeah,
gotcha. And then just a side note on that, I mean, how it relates to lending again. If I applied for a loan by myself, we do allow, and not every lender does, allow our clients to close in the trust. And there's two different methods. So closing in the trust means with, we'll say, Crista's assistance, they've prepared the trust, they've recorded a grant deed. So they've taken it from an individual and granted it into the trust name. So again, we do allow that. What we have to see is not the full trust, but we need to see the first page where it's who's the individual, and then the trustee, the name of it. We need to see the signature page, and then typically we like to see where, where there's the instructions that they convey real estate and kind of the terminology.
The general assignment.
There we go. Thank you. So with that, then when we close a loan, the borrower signs loan docs in their name personally, but it has the trust affiliated, and there's a trust addendum that gets recorded, but the property never has to come out of the trust. And that's, I think, pretty important, because even for one day, some, worst case scenario could happen. Of course, a devil's advocate, it's always slim, for a few days or one day, but you're never removing that. You're still protected. Adversely, some of the lenders that don't allow the trust, you would have to close in your name personally. You pull it out of the trust at the time of closing, and then as soon as the following day, you can record it and put it back into the trust. A little bit more effort, a little bit more cost, a little bit more time consuming, a little bit more risk. So,
well,
yeah.
I will also add to that, just because I do see this quite often, and I think it's amazing that you guys will close in the name of the trust, because so often we get calls from clients that years later we're updating their trust, and we'll do a title search to just see. We want to make sure it's in their trust, and we'll see it's not.
It got pulled.
And I'll say, did you guys do a refinance or something, because it's not in your trust?
Yeah.
And they had no idea, because it's confusing, right? They had no idea that it was even taken out of their trust, let alone it never got put back in.
And that's probably the biggest, I'm going to say, fault there on the lender is they don't want to take the risk. They don't want to take that accountability. They don't want to have the added cost or work that they didn't want to put that back in there for the client. And that's sad. So
Yeah.
I'm glad you're bringing that up. That's a very critical point to mention. Once you have this, you want to be able to use it. And if the home's not in the trust, I know we've talked about it previously. Yes, you can still possibly get out of probate, but it's just creating more work and more efforts.
It costs more money too.
It costs more money.
A lot more money. If something happens and your house isn't in your trust, we still have to go to probate and file a petition. It's not a full probate, but it's a petition asking the court to put it into the trust.
Mhm.
That's why we have the will. We call it a pour over will. And it's basically a function that says, everything should have been in my trust. If it wasn't, it should just get poured into my trust.
Yeah.
Yeah.
You had mentioned a few words, terminology-wise, irrevocable, revocable. I have the same understanding that it's irrevocable typically, it's revocable. When you first create it, typically, you can revoke it, you can cancel it, but then it does transfer to irrevocable once you pass away. There's no more changes to be made. Your wishes ultimately are done once you're deceased. Is that correct?
Yes.
Do you ever do any irrevocable right up front?
So it really depends on the assets that are involved for irrevocable trust. Generally, we would find irrevocable trust for someone if they had assets maybe over $10-20 million right now.
I'm ready to do that.
Okay. Yeah, so it's really more gets into the tax strategy side and the asset protection, right? Because once you have that irrevocable trust, you have a lot of limitations on what you can actually do with the property, and there's going to be more costs associated with it. For like if you had to have a trustee that was a professional trustee that managed it for you, you'd have to pay trustee fees annually. So again, we look at it more for those higher assets, planning and the asset protection.
And I would have to look at our guidelines, but I believe that we're unable to do it if it's an irrevocable trust.
I would assume.
Yeah.
So yeah, just because there's a lot more restrictions, right? They
Yeah.
don't have the access to it.
Right. Now, what I get also, which kind of goes hand in hand, and I've learned a little bit about this, is vesting. And I want to kind of chat about this because, one, nobody wants to talk vesting. And so we have, new buyers, even if they've owned for 20 years, most people don't know what the word vesting is or the different ways of vesting. Nobody wants to take the liability, so they just say, talk to this person, talk to this person. They always kind of push it off. Escrow companies are very good at that, where here's your sheet, here's what it means, tell us how you want to have your vesting. Mm-hmm. And so I just kind of want to go through those a little bit because one is I feel it's very important to obtain this information, but then two, it can make some differences that I've even kind of learned in that. And so one, you can vest in your trust, right? So if you have your trust, instead of personally, how you would do that, and I gave the example earlier, is you would prepare a deed to take it out of your name personally and put it into your trust.
Can we just clarify vesting and what vesting means?
vesting, how you hold title.
How you hold title, okay.
How you hold title. So I always think of, or try to explain just common analogy here. It's the pink slip to your house. Now, why does it make a difference is, again, it's if you're vested by yourself and you pass, what happens? If you're vested with another person, how much ownership do you have? How much ownership do they have? And then also what happens if one of the title owners passes? So there's always, the cause and effect of how you hold title and are vested. Now, tenants in common is the one I probably see the least amount. Go ahead.
You see it the least only because people don't write out tenants in common, but it is the number one way it is listed when there is no other language after their name.
Okay.
It's the legal automatic for title.
Yeah.
So if unless you include some of the other ones that you're going to talk about,
Yeah.
joint tenants,
Sure.
husband and wife as a married couple, if any of that language is missing, it automatically is tenants in common. You just don't list it.
Yeah, what I see, that is probably the least. So with tenants in common, you can, and I'm kind of rambling on here, so please correct me, or if you want to jump in. Tenants in common is you can allocate a percentage. I can own a home 1%, Crista can own it 99%.
Correct.
If I were to pass my 1%, I have to have an action plan in place of what's going to happen to my 1%. It does not automatically transfer to Crista.
Correct.
Yeah. Joint tenancy. Yep.
One more thing I'll say
Yes.
with tenants in common. That 1%, if you do not have an action plan, would be for your 1% to have to go through probate court.
Yeah.
And people they don't see this when they
And
when
that
they're
could
looking at
tie
title.
up the other 99% stakeholders, and I mean that could be time if you want to sell, but you can't because it's tied up.
There's no title. There's cloud
Oh,
on
my
title.
goodness.
Exactly.
Yeah. Then there's joint tenancy, and that is kind of equal distribution. So if you and you do not have to be married, it can be anyone, hold joint tenancy. If there's two of us on title, it's 50-50. If it's 3, 33 and a third percent. 4, it's 25%. If, again, Crista and I owned a property as joint tenants, we're 50-50. We do not have to say 50-50. It would just be Gregory Joseph Abrams, Crista Hermance as joint tenants, and we would describe a married man as a sole and separate property, get into all the technicalities there. But if I were to pass, notice I keep saying I'm passing here. Yeah.
I appreciate that.
Okay. When I pass, statistically it's true with men passing first, my portion of ownership automatically transfers to you.
Correct.
Okay?
Yes.
I see that a lot, and we do a lot of joint tenancy for that reason. If you don't have an action plan in place yet, then that's where we see that.
Yeah.
Now, the same type of thing, but different, is community property with the right of survivorship. It acts the same, but it's exclusive to married couples.
Correct.
Okay. And then typically when you have vesting with more than one person, you always have to describe each party. So again, if Crista and I were to hold title together, it would be Gregory Joseph Abrams, a married man, as his sole and separate property, and Crista Hermance, a married woman, as her sole and separate property. Or if I were single, Gregory Joseph Abrams, a single man, or an unmarried man. Unmarried means I've been married previously. So with multiple parties, you have to describe them individually and then how they own or hold the vesting together. Yeah. Now, I ran into a situation with, and this was kind of new to me, I have a very close friend of mine, and his parents bought a home in Oxnard 50 years ago at least. His dad passed away, and they recorded an affidavit of death, taking him off of title, so it was just his mom.
Yeah.
At some point, the mom added him onto title, and so then it was joint tenancies between the two.
Okay.
Mom then goes and gets a trust, and she gets remarried, and she goes to, I'm not going to name the company, but she went to a different attorney that prepared it, and she did not want this home in the trust. She wanted her husband's home because she already had this one with the joint tenancy with her son. They erroneously recorded a deed to put it into the trust, okay? The county, now she's owned this for 50 plus years, so her property taxes were very low. The county came back and they're trying to reassess her taxes, even though she's never come off title, because it was joint tenancy to the trust versus tenants in common to the trust. And I had never heard that. I had never been aware of that, but obviously there's something with the county, and I mean, I made them show me the code. Like, I want to get deep into it, and that's basically what it is tenants in common has some exemptions, whereas joint tenancy did not, and they felt in the way that it was done, the mom came off, so there was no original stakeholder in that, and that's why they wanted to reassess her.
So they're fighting it?
They're fighting it, yeah, and I believe it's getting resolved because they were able to prove that their wishes were not done. So here's the moral of the story here, folks. Hire a professional that is licensed legal attorney, that knows their stuff, that really is knowledgeable, that will help record all of these documents for you. It prevents these headaches. And so the old adage, you get what you pay for.
Yes.
This is coming into play, that she's now stressed out. And the way the county works is backwards. They're going to reassess her. They have. And then they're going to bill her. So there's two components. The tax assessor, they pass that value to that new value to the tax collector. You cannot appeal until you pay those taxes.
Correct.
So she went from like $500 a year in taxes. They were going to reassess it from $50,000 up to $400,000. That was a big difference. That was thousands of dollars that she had to pay just to go into the appeals to fight this.
Yeah,
So,
and then if she wins the appeal, they will credit her back that
They
money.
will.
It
But-
just takes years.
and she's limited income, she's on Social Security, you know, yada yada. It's money that she didn't have, and very costly mistakes. So.
Yeah. And one thing I wanted to add, just as you were describing this fact pattern, because I feel like this comes up so often, is when a parent passes, or there's one parent that has title in their own individual name, I can give lots of reasons why you should not add your child to title, as you said it was done here. And one of those big ones is, in this example, I don't know if there were siblings, but if something happened to mom while mom was listed with her son as joint tenants, mom's portion at mom's passing, all of the house would then go to the son. And I see this happen where people don't understand what the vesting title says or what it means, and when somebody passes, because if there were other siblings, because this happens to us, where siblings come to us and they say, well, my brother got added to title and now mom's passed and he got the whole house. Mom didn't necessarily know when she was signing title what that vesting actually meant, right? Even if it was just in the interim of getting a trust. And so that's one big issue, is really understanding what can happen if you just add somebody to title. The other issue I have is capital gains taxes.
Yeah.
When you add somebody to title, you're taking away the ability that when you were to pass away, if they were just to inherit it, that property would get a step up in basis on the capital gains taxes, which means that if you purchased the property for $50,000 in 1970 and now it's worth $1 million, when you pass, you're getting $900,000 of capital gains taxes that would be now due to the son when he sells it. Whereas if he had just inherited it, he would get that step up in basis from that 50,000 to the $1 million.
Yeah. Well, you're hearing it. You're hearing every reason why you need to consult. And I'm assuming, I don't want to misspeak, with your services, is this something that people can call and for hire pay to get a consultation on vesting and kind of the, you know, the legal counsel of stuff.
Yeah, so we actually have a service that we provide. It's called Title Check.
Oh.
And I don't know the exact cost off the top of my head, but it's very reasonably priced. It's very inexpensive to just, we want to know, because we have a conversation with you, what is your intention with this house? Because then we can help you identify what exact language is going to be there to send that to you, so you can provide that to title, so they can put that on your grant deed.
Yeah.
Because a lot of times people will just Google it, right?
Yeah.
How should I hold title? Not understanding the ramifications of what that title actually means.
Yeah.
I think that's such an important part of it.
I think this is just a personal pet peeve, but I always cringe when I see a husband and wife and they take joint tenancy.
Mm-hmm.
And I'm like, your husband and wife is community property. It's the same thing. It's just more proper, appropriate. It's how I see it anyways.
It's not even just that though, is you can cringe for a better reason, is there's a tax savings to owning it as community property.
Oh, I love it.
Rather than owning it just as joint tenants. And so, and so two things. Let's come back to the community property one, but when you own property, if you're married and it's a community property asset, you should take title as community property, because then, like as I was saying with the step up in basis, when one spouse passes, the spouse then gets a step up in basis on that property value.
Oh, wow.
And then if it's married as community property, it gets a double step up in basis when it gets then transferred to the beneficiaries or the heirs that would then be receiving it.
Oh,
So it gets it
beautiful.
at each passing if it's owned as community. And so that's why it's really important to make sure, because that they will get a huge tax savings on that at their passing.
Yeah, I definitely need your service. I need some flyers. I need some stuff. During the process, we need to be able to give this as a resource to our clients. And I think, again, it's not trying to solicit or sell something as much as it is that critical that I'm hearing that you're properly vested and how you hold title, just even doing the title check as you called it. But of course, you should have a full plan. I mean, again, as you have assets, you have a family, you need to protect. You know, it's not just for yourself, it's more for your heirs, being honest.
And I actually talk about this in the workshops when we do them, is I think of estate planning is it takes that burden off of your loved ones.
Yeah.
You know, I had this client, her mom had just died, and I'll never forget, she says, I'm so angry. You know, I'm so angry at my mom for not having any of this stuff documented, not having a plan in place, because my mom just died, and all I want to do is be sad, but I can't, because I have all this paperwork that I have to do.
Yeah.
And you know, that to me was so impactful, because at that point, you know, it wasn't just you need a plan, it's you need a plan, and here's why.
Yeah.
Right? Because when situations that we work in happen, it's stressful, it's emotional, it's sad, and people are in this heightened state of emergency, right? And if they have a clear plan, it just helps alleviate some of that, right?
Yeah.
It makes things just easier for them.
Yeah, no, for sure. And I think a lot of this, and we can, you know, you probably hand in hand work with some financial planners, but also like even life insurance and things like that. You know, part of our plan is, you know, I've thought it through, like, odds are, statistically, highly statistically, I'm going to pass before Sarah. Well, we have multiple properties, residential, commercial, vehicle, we have all kinds of stuff. And the last thing I want her is to grieve, and then, as you're saying, dealing with paperwork and then the financial responsibility. So we're loaded up on life insurance. I've already told her, when I pass, you take a year off, you go on vacation, meet some other guy, whatever you need to do, you go do that, but you're not stuck dealing with my financial affairs, you know? So, I mean, we're a team, but it's ours, but it can just be overwhelming. And when your head's not in it, and when you're trying to grieve, it's just, you know, hey, I'd rather see her in the Bahamas sipping on a little martini or something, who knows?
Yeah.
So, yeah.
I did want to talk about community property.
Yeah,
I think that's something also that's important. So oftentimes people just have this misconception that when they own property with another person, it just automatically goes to the other person. And when I say that they own it, is they think that they own it together, right? Like we'll have conversations with people and I'll say, do you know how you hold title to your home? They're like, oh yeah, I own it with my spouse. I was like, okay, let's just check the deed and see. And lo and behold, the spouse is not on title. And they'll say, oh yeah, I remember refinancing it and I would get a lower rate by myself and they never got put back on it, right? And so if something were to happen to that spouse that was on title, it wouldn't automatically just go to the other spouse. Like you had said, they had to file an affidavit when one spouse passed. That's usually the way it goes if it's titled properly. But in this example that I'm giving, we would actually have to go to court and file a petition to get that house then transferred back to the spouse. And if there was children that maybe were from different marriages, it could complicate it more where they might not want to give it back to that spouse. Right? And this all just leads up to more money and things that could cost a lot to try and fix.
And here's a little financing tidbit. So how we handle that, California is a community property state. For conventional loans, even government loans, you can apply, if you're married, individually. Now, if I am the one that takes out the loan, my spouse can also be on title, and so she's a title-only borrower. So it'd be, the loan is Greg's responsibility, but then title, we have Greg and Sarah. And for lenders, they do allow that. Some lenders will try to just, again, if it was Greg and Sarah that owned it, and then I went to refinance it by myself, then they would try to pull my spouse off. And you should fight that. And honestly, you can have title-only borrowers. It does not have to be your spouse. You can have as many as you'd like. You can have your neighbor, you could have your uncle, you can have, any different person, but it's okay to have title-only borrowers. And so I think a great point that Crista brought up is make sure when you're doing the financing, if it is by yourself, that they're not touching the title, pulling it out of the trust, or pulling the spouse off, where it's Greg is a married man as his sole and separate property. Now, when I do that, they will prepare a deed going from Greg and Sarah, or my trust, to me individually as a married man as sole and separate. A lot of times, if you acquire a property, so not just on the refinance, but during acquisition, then they will want an interspousal deed as well. So this is a specific deed that your non-titled spouse has to sign. And it's them acknowledging, I am not on the loan and I am not on title. So I would imagine that interspousal deed is like why you have to go to the court and really petition for it, because you've signed something like, no, I don't want to be on it, specifically for that.
Yeah, so, exactly.
Goodness. I know all these little technicalities, and during the process, sometimes it can be overwhelming. So it's, always ask questions, and if you have a path or way that you want to hold it, you need to make sure that you're holding adamant to that. Are we ready to go down the sad, lonely road of probate?
Sure.
Oh goodness, tell us what probate's all about.
Okay, so probate court is the process that when somebody passes away, the assets that they own in their individual name then have to go through this court process. So generally you would have a family member that would come forward, whether you have a will, and the will would identify who that person would be, as we would call it a personal representative, or somebody would come forward, maybe if you didn't have a will, they would file a petition with the court, thereby opening that probate proceeding. You would get established as the personal representative. You would get a set of letters. Those letters are basically what you would use to start acquiring the assets of the deceased. During this time, we have publication that needs to be done. So it gets published in newspapers, their creditors are notified, and then as you're gathering all of the assets and putting it into a stated account, it generally takes a really long time. So on average, especially in Ventura County, we're looking at 1 to 2 years for a probate proceeding. LA County, more like 2 to 3 years. Orange County, we're looking at 2 to 4 years. It really depends on how busy the court is and how quickly you can get hearings set. So once all of the assets have been kind of gathered together, creditors get paid, and then everything gets left over, the court says, okay, yep, this looks good, this is how it's gonna get distributed, they approve it, and then the money gets distributed to the heirs. So this can be really detrimental for maybe families where the breadwinner passes away, and if they had no access to accounts, the accounts are out of their hands at this point, and they've had no access to any of that money.
Wow. I'm sure you've got some nasty stories on probate. Any highlights? Any good stories? Any bad stories?
Well, I do have an interesting story, just because you brought up the holographic will earlier.
Yeah.
So we had a client, her sister had passed away, and she was 85 years old, and she had done a holographic will. It was just on her little side table next to her chair in her grocery list, right? It was a little grocery notebook.
Yeah.
And it was a very simple will that just basically said her name, I leave everything to my sister, she signed it and she dated it. And so we are having to go through probate, and she owned a home, she had a rental property, and so her estate was over $1.5 million at this point. And as we're kind of going through the probate process, I get an email. It's from her son. I didn't know about the son. And I guess what had happened is he had left home when he was 16. He found out mom had passed away, and he had sent me an email. And so I called my client and I was like, did you know about this son? And she's like, yeah, but he's been gone since, and this was 40 years ago,
Oh my
right?
goodness.
I mean, so many years before. So unfortunately, she had done a holographic will, right? She didn't work with an estate planning attorney where the questions would have been asked, do you have any children? Because we would have needed to specifically disinherit him. And so his claim was that, well, she didn't know I was alive, and so I should be entitled to her estate. And we had to settle with him.
Oh my goodness.
Because it's true, right?
Yeah.
He was able to come after it because she didn't specifically disinherit him in her holographic will.
Wow.
Yeah.
And I know you've shared the cost roughly of probate. I mean, what's the typical probate cost?
So it's all based on the value of the estate, and sometimes people get confused with what the value means, but like if you own a home, it's not how much equity you have in the house, it's actually what the fair market value of that home is.
Mm-hmm.
So let's say that there was an estate worth $500,000, it would cost $26,000 in fees to go through probate court. And then you have other fees on top of that, probate fees, bond fees, publication fees. That's another $2,000 to $3,000. It's almost $30,000 for a $500,000 estate.
Yeah.
You're looking at $800,000. What's the median price for a home right now?
It's over $1 million.
It's over $1 million.
Yep.
Wow. Okay, so $800,000 is over $40,000 in probate fees.
Yeah. So that the median and average is like $1,050,000 in the city of Ventura.
Okay.
So yeah, as you're saying 500,000, I'm like, I don't know anybody that has that.
Yeah.
So yeah, so you can hear it. I mean, if you're purely one of those that are just the numbers guy, and you're like, hey, I don't want to spend the money on a will and trust. Well, how much does it cost
To not have one.
to not have one?
Yeah.
Exponentially higher.
Absolutely.
So, yeah.
And it's not just the death aspect either, right? So a lot of people think, I'm young, I don't need a plan, or I don't want to spend that money, or I'll let my family deal with it, right?
Yeah.
After. But it's also what if you get sick? Because the majority of people do not just die. They're gonna be sick before they die.
Yeah.
And that's what the estate plan does, is it has specific documents that care for if you were to get sick. How is your stuff supposed to be dealt with, right?
Yeah.
It's like a bank account. You're like, well, I don't need an estate plan because I have a beneficiary in my bank account. Well, that's great, but your beneficiary, if you get sick, can't withdraw money. They only get access to the money when you die.
Yeah.
So nobody can actually access the money to pay your bills.
Yeah, and that leads us right into the medical directives. I mean, what are some of those, and provide some examples of what they do.
Sure. So we have in California what's called an advanced healthcare directive. And this is where you identify an agent to be able to make healthcare decisions on your behalf if you were unable to do so. The healthcare directive also allows you to put certain end-of-life decisions. Do you want to be buried? Would you like cremation? Would you like to provide any type of organ donation? If you were in a persistent vegetative state, would you want to be kept on prolonged life support with extreme measures or taken off, right? And that's all stuff that's kept in that advanced healthcare directive. It's confusing because we also know what's called a living will. And a lot of people say, oh, I have a living will. And it's those specific end of life decisions. A living will is not a will. A will is a different document that gets filed when you die. A living will is the healthcare side.
Got it. Yeah, I ran into the hard way with my mom. We're originally from the Central Valley, and prior to her relocating down here, which she's here now, she owned a home, and I had just gone and visited her, and then the very next day I get home, her work calls me, and I'm like, what happened? Well, she passed out at work, and she wound up in the ER and all of this. The hospital would not tell me anything. They were not allowed without specific forms. Yeah. And so thankfully, I had done a loan for the head of security of that hospital, and I called it a favor, and I'm like, I know you can't tell me too much, but as a security person at that hospital, can you walk by her room and just kind of see if she's coherent, until I can get there? And so, oh my goodness, what a huge scare. Yeah. And then after that, it was like, Mom, what are you doing? And I think that's some additional questions that I have, just kind of thinking about that in that situation. What are some of the things in place to help? Maybe somebody hasn't passed, but now they maybe have Alzheimer's, or they're not able to make their own decisions. With the medical directives, you can have somebody assigned prior to, and then does it take a judge, or what? How do you get somebody assigned to make financial and all the decisions for you?
So ideally, they would have completed an estate plan. It's a comprehensive estate plan that includes all the documents we've talked about, including a power of attorney document. Yeah. And if they have done that before, then it makes things a lot easier because you don't have to go to court to get what we would call a conservatorship. Yeah. And because the documents say, here's who I want to be able to make healthcare decisions, here's who I want to make financial decisions and act on my behalf. Because without these documents, and we see it, so frequently, where a adult child would call in and say, my parent has Alzheimer's, and we need to sell their home and put them in assisted living. And I'll say, okay, that we can try and help. Let's pull title. We see that the home is owned in the parent's name alone. And at this point, I say, do you have a power of attorney? Do you have anything? And they're like, nope, we didn't get to it. They haven't gotten it done. And because they do not have the mental capacity, because of where they're at with Alzheimer's, they can't actually sell the home, right? They can't sign the legal documents. Yeah. And that's where a court's conservatorship would be needed to get the family member identified as the person who's going to be in charge, and then they can sell the home and put them in the assisted living. Oh my goodness. But a conservatorship could be $5,000 to $10,000 to $15,000. Right. Whereas if they had just done a comprehensive estate plan in the beginning before they got sick, then it just would have been okay. It's in place. Yeah. Wow. I'm hearing more and more. It's like, I'm glad I have my stuff in place, but those of you that are listening that do not, I think it's something that I hope you're listening to all of the different facets of how technical it can be. And, even just thinking about, I'm going to get a will or a trust done, how important it is to have the proper team do it. I know that there's online, you can do, online, buy software for $30 and do your online taxes. You can do your online will and trust. You're not getting the counsel, the advice, the questions answered. It's, I always say in mortgages, there's no two loans that are alike. And that's what I love about it, but it also makes it a little challenging. Not everything is 100% black and white. There are those gray areas, there are those exceptions to the rule, there's listen to my situation. Everybody has their own little situation. To have the proper advice and counsel supporting you, and not only that, checking up on you. Hey, 5 years ago, we did your plan, but we see you did a refinance, you pulled it out of your plan. What are you doing? We're here to help you. Oh my gosh, Crista, you are needed. Keep spreading the word. Yeah. Oh my goodness. I do have an interesting DIY story. So I had a client, his dad passed away, And he said for years, he told his dad, Dad, you need to get your plan done. You have to get it done. Dad did his plan. And so son got off his back.
Yeah.
Dad passed away. And son sent me his estate plan that he did. Come to find out, he did it online.
Okay.
It was not valid.
Oh, yeah.
Do you know why?
No, please share.
He forgot to sign it.
Oh, of course.
It was never properly executed. And I see this so often. Somebody will do it online but not understand the legal requirements to make it valid. And the courts won't accept it,
Yeah.
right? And so he had, I think it was like a $2.5 million estate that we had to take through probate court.
Oh my goodness.
Mm-hmm.
Yeah.
And
That
so
costs money.
it costs a lot of money,
Yeah.
right? And I feel like with the DIY plans that I see, where it gives people this false sense of security
Mhm.
because you don't know that it won't work
Right.
until it's too late.
Absolutely.
Yeah.
I couldn't have said it better. What is the proper storage place for the documents? Like, do you want to just throw them in a drawer and hey, I've got them? Like, what do you recommend?
So I recommend that if you store it in a safe, your emergency people know where that safe is and how to access it, right? If
Yeah.
it's a key code, they need the combination. If you have a safety deposit box, you need to make sure that your emergency people know and can access that safety deposit box, because we've had clients where they put it in a safety deposit box, and there are clients, because their family's coming to us after they've now passed and they can't find it.
Mm.
We find a slip for a safety deposit box, go to the bank. Well, guess what? We have to get a court order.
Yeah.
So we can't even access the documents to know what's in there until after. So anywhere you put it, just make sure your emergency people know where it is and how to access it. I generally also recommend that you have it stored somewhere in the cloud safe. There are systems that have, like, especially for estate planning documents, that you can store up in the cloud to keep it secure. And then upon your passing, your emergency contacts can send a request and those documents be emailed to you, or you get access to them.
That's cool.
Right?
Yeah.
But definitely having a scanned version somewhere up in the cloud, because like in Ventura, we had a bunch of people that their estate plans were burnt in the fires,
Yeah.
right? But if you have a copy of it, then this would still be valid.
Yeah. And I kind of commonly find, again, we have to request copies of the trust. A lot of times when I'm requesting copies, somebody else has already dug through them, and it's not always there all the time.
Things are
And
missing or something.
yeah. So I think having an electronic copy broken down into segments of what it is, I don't need somebody's will, but I need a portion of their trust. So just send me the trust portion, that they don't have to go to the original documents, tear that package up each time, put it in a different spot, misplace them, forget to put them back.
Mhm.
I think having the electronic copy readily accessible, that you can send bits and pieces or all of it if needed to different professionals, and then having the originals and making sure that somebody knows, as you said, where they are.
Mhm.
Purposely, we have a safe, and I've never kept it in the safe because I'm like, okay, if Sarah and I were to pass, somebody's got to find it, somebody's got to access it.
Mhm.
And my brother-in-law is the next one, the in pecking order there to kind of handle our affairs. I don't want him in my safe. I don't know. So anyways, I think it's like you said, just sharing where it is, and everybody's spot's going to be different, but definitely, yeah.
With the electronic versions, like, we provide a USB drive and we scan every document and label it, because we want clients to be able to use that to send to the mortgage company.
Perfect.
Like,
Yeah.
if they need the certificate of trust or they need the actual trust, and it just makes it super easy. So often we're dealing with people where somebody's passed away, or they want us to review their old trust, and they bring in this huge binder that has never been scanned, right? They have no electronic
Yeah.
copies of it to be able to send to us, so they have to come to the office and bring it in. This just makes it so much easier.
Updates to the trust. Sarah and I buy another property. Is it as simple as just redoing the schedule? I think it's Schedule A that has the assets, like adding that property, or is it something that you recommend every so often being fully reviewed, just circling back to your assets? Our 401ks are growing in value and other assets are growing in value. What are your thoughts?
So generally when you purchase a home, you don't have to make changes to your trust. Like you said, right on your Schedule A, the new property, but making sure it's titled in the name of the trust is the biggest thing.
Okay.
Right? That's the biggest. Generally, we'll say every 3 to 5 years to do a trust review, or big life events, right? So maybe if you had minor children that are now adults, we want to make updates to your plan. If there was a death in the family or a death of somebody that you had listed as an agent, we want to make sure that that gets updated. If somebody got married, if names changed, if there was a divorce between the couple who had the trust, right? Or a divorce that's coming, we want to make sure that there's estate planning documents in place, because surprisingly, there are people that actually pass away in the middle of a divorce proceeding.
Yeah.
And it's I think we actually have one of these cases right now that we're having to fight because they weren't legally divorced at the time of the passing. And so the spouse that's remaining wants everything.
Yeah.
So.
Interesting. Wow. Oh my goodness. Well, you've planted the seed, you've got the buzz. I'm a huge advocate for what you do, and I can't thank you enough. I mean, again, the message that you get out, and hopefully more and more, we're all sharing the message that everybody should have a plan. Really, everybody should. So
everybody should. Anybody over the age of 18, but especially if you have minor children and or own a home, you need a trust-based plan. Yeah, beautiful. Are there any topics, anything that we didn't cover that you think is valuable before we get going here? I would say for anybody that's listening that has young adult children, anybody over the age of 18, it's good to have some documents for them too, right?
Oh, yeah.
A lot of times you don't think about, if you're young, needing plans, but generally we would recommend a advanced healthcare directive, a HIPAA authorization, and a power of attorney. And we actually have we call it our college safeguard system, very inexpensive digital plan that you can do. And this is for families where their kids are going off to college, right? Because I had a client whose son went away to Texas to go to school, and she gets a call from his roommate that he's on his way to the emergency room. She calls the hospital, and guess what?
He did.
Just like you. No.
Oh.
Just like you and your mom.
She couldn't get any information.
Just information for your mom. She couldn't find out what was going on, right? And he ended up being okay, but as soon as he came home, she had him sign these documents so that if this ever happened, she could fax the stuff over to the hospital and say, you can talk to me, he's given permission. Yeah. Right? And parents don't think about that when their kids turn 18. You have no legal authority to get that information anymore.
And I would have never thought of that. So that is beautiful advice right there. Yeah. Wonderful. Okay, how can our lovely guests, how can they find you, Crista? Well, you can follow me on Instagram. I'm at Estate Planning Mom. You can go to our website, iwanttoprotectmyhome.com. And we do free phone consultations, just trying to get information on what estate planning is. If you have a situation where a family member's passed away, we help with all of that. A lot of it's just we don't know where to start. Yeah. Right? And we can help with that. Yeah. I'm going to start pushing out some information of Crista's. It's valuable information. As you're a first-time home buyer, we're going to start giving you the tools, how to get your vesting title checked, and just some of these simple basics to get your kind of introduction into the will and trust. I think it's that important. So Crista, I can't thank you enough for coming and joining us today, sharing about wills, trusts, probates, all these tough things that we don't always like to talk about, but it's very, very critical and very important. And so I appreciate your expertise and again the education and word that you're getting out. So thank you so much. Thank you. All right, everybody. It's kind of the end of the episode today, but that doesn't mean that we're gone. Please follow, like, subscribe, all that good stuff. This is Greg Abrams on G Money, real talk on everything mortgages and real estate, and we're out. See you next time. Peace.